Thank you, everybody. Thank you for coming along to this seminar about, well, we call it Making Your Mind Up, Abusive Process. In 1981, a little-known British four-piece pop band called Bucks Fizz came out of nowhere to win the Eurovision Song Contest. They went on to chart success with unforgettable standards such as The Land of Make-Believe and My Camera Never Lies. But their Eurovision pop-winning song, which brought them their initial stardom, was a song called Making Your Mind Up, which some of you may remember for its innovative skirt-ripping dance routine. Now, this seminar, unfortunately, is not about 1980s pop music, nor indeed is it about British winners of Eurovision song contests. But I'm sure that the topics and dilemmas that face modern litigators, and which Benji and I are going to talk about today, are exactly the sort of issues that the writers of Bucks Fizz's greatest hit had in mind when they were writing the song. So what are we going to talk about? The subject matter focuses on abusive process, but is specifically directed at what happens where a choice has to be made as to how a case is to be put, and the extent to which that choice can prevent a party from taking a different tack at a later stage in the proceedings. So I'm going to talk about the somewhat long-running case of Ashraf and Lester Dominic, which some of you may be familiar with, and specifically its culmination in a hearing before Joanna Smith, J, towards the end of last year. Benji is then going to consider the recent case of what I'm going to call SCAT, because I can't pronounce the full title of the case, which looked at Henderson and Henderson issues. And you'll note that we've slightly cheated here because, strictly speaking, I don't think SCAT is actually is dealing with abusive process at the interlocutory stage, but we thought it worth dealing with as a recent example of Henderson and Henderson in action. Benji is also going to discuss the Discovery Land case, which was when it was at the interlocutory stage, and the difficulties that can arise when an amendment is allowed but the other party subsequently seeks to strike out the case. So to the Ashraf case first. It's tough being a claimant, all those difficult questions. Who should we sue? What courses of action do we pursue? Do the defendants have any money? What happens if we lose against X? Is there a claim against Y? Essentially, it's a world of possibilities and therefore a world in which there are necessary choices to be made. You want to go after the strongest targets with the deepest pockets, and sometimes those two things will coincide. You don't want to sue parties where the claim is weaker because of the cost risks that can give rise to. And of course, English law makes it easy for you by being one of the most sophisticated, and then for which you might read the word complex, systems of law in which you can sue. And this seminar is all about when things go wrong, when things don't go to plan, when the choices that you made at the outset of the litigation turn out to be the wrong ones. What can you do to get back on track, and will the court let you do it? Now, the inspiration for the seminar, as I've indicated, is the recent decision of Mrs. Justice Joanna Smith in the Ashraf case. And that case is as good an illustration as any of how, as to how things can go drastically wrong, where you try to be too clever in relation to the different permutations of the case you want to pursue. It also, in my view, might be said to be an example of the use and possibly abuse of statements of truth, but we'll get to that in a moment. What about the facts in Ashraf? Now, Ashraf arose out of a theft from a solicitor's client account by one of its employees. And the story starts with a man called Mr. Ul-Haq, who wanted to sell his house in Ealing, in Argyle Road in Ealing, to a Mr. Atarian in 2008. The sale price was 1.25 million, and Mr. Atarian was to take out a mortgage from Bank of Scotland to assist with the purchase. The money, once paid over to Mr. Ul-Haq, was then to be used to pay off Mr. Ul-Haq's mortgage, which coincidentally was also with the Bank of Scotland. So far, so standard. All parties instructed a firm of solicitors called FLP Solicitors to act on their behalf. The contracts were exchanged, and a transfer for the property, a Form TR1, was executed by both the seller and the purchaser, albeit that document wasn't witnessed. And the Bank of Scotland remitted the funds that it was lending to Mr. Atarian, the purchaser, for the purchase to the solicitors, FLP. And at that point, things went wrong, because while the funds were in FLP's client account, they were stolen by one of FLP's employees, and completion of the sale didn't take place. Now, that obviously left things in a bit of a mess. The Bank of Scotland didn't receive money to discharge Mr. Al-Haq's mortgage, which remained on the register. The transfer wasn't witnessed, so Mr. Atarian couldn't be registered as proprietor of the property, and neither could his mortgage with the Bank of Scotland be registered either. Now, attempts seem to have been made at that stage by the bank, who, in practical terms, was really the party at risk there, to claim for the lost money against FLP's insurers. But in a story which may sound a little bit familiar, though some of the money was recovered in this respect, it appeared that FLP had reached their limit of indemnity, this not being the only fraud that had taken place. 2 years later, in an apparent attempt to sort things out, a TR1 purporting to record the transfer of the property to Mr. Atarian was registered at the land registry. But Mr. Al-Haq subsequently contended that that document was a forgery. Nevertheless, the effect of the registration was that Mr. Atarian became the registered proprietor, and in due course the bank, exercising its powers under its charge, sold the property to third parties. Thereafter, Mr. Al-Haq sued no fewer than 7 defendants, including 2 firms of solicitors, the Bank of Scotland and the Chief Land Registrar, in relation to the registration of the title. Sadly, after the commencement of proceedings, he died, but the proceedings were carried on his behalf, or on behalf of his estate, by his partner, who was Miss Ashraf. There were then a string of decisions, one of which went to the Court of Appeal. However, the one that we're most interested in is the most recent one in front of Mrs. Justice Smith in a judgment that was handed down in November of last year. And that judgment concerned the claim against the Chief Land Registrar. And that was a claim under Section 103 and Schedule 8 of the Land Registration Act. And essentially, it was a claim for compensation in the event that there was a mistake on the register of title causing loss to the claimant. And so Mr. Al-Haq was saying, well, there is a mistake on the register, and I'm entitled to compensation in respect of that mistake from the Chief Land Register. And at the heart of that issue was how the funds were treated by FLP at the point that they were stolen. One of the real complexities to the case was that FLP had acted both for the seller, Mr. Al-Haq, the purchaser, Mr. Atarian, and also for the Bank of Scotland. And we know the money was stolen while it was in FLP's hands, in their client account, but that gave rise to the question, well, whose money was it at the relevant time? Was it Mr. Atarian's money, in which case the purchase price had never been paid to Mr. Al-Haq, and he was either not a vendor at all, because there'd never been a valid transfer of the property, or, if there had been a valid transfer, he was an unpaid vendor entitled to be paid the balance of the purchase price with an unpaid vendor's lien on the property. Alternatively, was it Mr. Al-Haq's money at the point when it was stolen? On that basis, the purchase price, once it was received into FLP's client account, was treated as having been paid to Mr. Al-Haq, and properly speaking, the property should have been transferred to Mr. Atarian, and it was difficult to see how the claim against the Chief Land Registrar could succeed on this basis. Mr. Atarian, the purchaser, would have paid the money for the property, and he would be entitled to have had it transferred into his name, so there was no mistake on the register. Now, that's the point at which it became complicated as far as the claimant was concerned, because the claimant's case went through a number of iterations on this crucial question as to whose money it was at the point when it was stolen. Initially, in the amended particulars of claim, the claimant asserted, at least implicitly, that the money remained belonging to Mr. Atarian at the point it was stolen. And therefore there was no valid transfer, or if there had been such a transfer, Mr. Al-Haq was entitled to the unpaid vendor's lien. In mid-2019, however, the claimant produced a draft re-amended particulars of claim which set out a different case, namely that the money was initially paid to FLP as solicitors for Mr. Atarian and his mortgagee, but that in accordance with ordinary conveyancing practice, the pleading said, the money was treated as having been paid to Mr. Al-Haq and then to his mortgage company before it was stolen. But no application was ever made to implement this draft, and when asked about it, the claimant was equivocal as to her intentions. By 2021, in the face of a strikeout application made against her by the Chief Land Registrar, and at the hearing of that application, the claimant's counsel indicated that she would be applying to amend further her statement of case to, in counsel's words, clarify her position. Now, the judge, in his judgment following that hearing, made it clear that that was unsatisfactory. He noted that it was hard to avoid the impression that the claimant had distanced herself from the draft pleading that had been produced in mid-2019 because she appreciated that it undermined her case as against the Chief Land Registrar. The judge also indicated in his judgment that the claimant's pleading was defective for other reasons, and essentially he made it clear to the claimant that she was in the last chance saloon in relation to her pleading. He said that he would have been minded to make an unless order that she correct the problems in the particulars of claim within a certain period of time. In the event that was overtaken by events because an order was agreed that didn't impose that obligation. In April 2022, the claimant had another go at pleading out the case with a further iteration of the proposed re-amendment to the particulars of claim. Now, this draft pleading, in contrast to the previous drafts, was verified by a statement of truth by the claimant, and it set out two alternative factual cases. Factual case A was that following receipt of the money by FLP, the money was treated as having been credited to Mr. Al-Haq and then used to redeem his charge with the Bank of Scotland. And on that basis, the money, when it was stolen, was money belonging either to Mr. Al-Haq or to his bank. And the subtext of that alternative, it would seem, was that that supported the case against the Bank of Scotland, because essentially Mr. Al-Haq was able to say, well, your mortgage was paid off, so I'm not liable to you for the loan that mortgage supported. So that was factual case A. Factual case B, the alternative, was that the money was stolen before it could be credited to Mr. Al-Haq. So it was never received to his credit, nor was his charge ever redeemed. In other words, when it was stolen, it beneficially belonged either to the purchaser, Mr. Atarian, or to the purchaser's mortgagee, which again was Bank of Scotland. Now, the statement of truth signed by the claimant was, I believe that the facts stated in the pleading, but as to either alternative factual case A or alternative factual case B are true. Now, the purpose, as I've said, of factual case A was so that the claim could be pursued against or maintained against Mr. Al-Haq's bank, the Bank of Scotland. But the alternative was obviously aimed at the Chief Land Registrar on the alternative basis that the property should never have been transferred to the purchaser, and therefore the Chief Land Registrar ought to pay out compensation. Now, at this stage, the Chief Land Registrar consented to this amendment, but one of the other defendants resisted it. What happened next, and I hope you're keeping up with this, was that in February 2023 there was a yet further amended version of the particulars of claim. Again, this was verified by a statement of truth. Now, this draft abandoned the idea of having two alternative factual cases. Instead, it pleaded a factual case that following receipt of the money by FLP, it was allocated to the credit of Mr. Al-Haq and was then used to repay his mortgage. So in other words, what was pleaded in this draft pleading was factual case A, and factual case B just disappeared. It wasn't pleaded as an alternative. It was argued at the hearing before Mrs. Justice Smith that the alternative case was there sort of in the periphery of the pleading in a somewhat more opaque form, but that assertion was rejected by the judge. Now, this last iteration of the draft pleading triggered an application by the Chief Land Registrar, perhaps understandably, for summary judgment, because they said, well, if you're saying that factual case A is correct, i.e. you, Mr. El-Haq, received the money, then that means the registration of the title in the name of the purchaser was perfectly fine. There was no mistake and there's no case against the Chief Land Registrar. And so he made that application, and he made it in conjunction with an application to strike out for abuse of process. Just in case anybody thought there were enough draft pleadings floating around in this case, in August 2023, there was a further draft pleading, a yet further draft amended pleading that was produced. By this stage, the claimant's claim against the Bank of Scotland had fallen by the wayside. So the factual case A was no longer really going to help the claimant. And so this version changed the position yet again. Instead of factual case A, the only factual case in relation to the allocation of the monies in the hands of FLP was factual case B, i.e. that at the moment of the theft, FLP was still holding the money on behalf of Mr. Atarian, the purchaser, or his mortgagee. Now, at the hearing of the Chief Land Registrar's application for summary judgment, Mrs. Justice Smith refused to allow in the latest draft. She refused to allow in the latest draft of the amended particulars of claim on the grounds that the claimant needed relief from sanctions to plead it, and it was inappropriate to give that relief. But that created something of a problem, because when you look back at all of these slides, you'll see that all of these pleadings have all been draft pleadings, and one had to go back to the point at which there was a formal pleading that had been accepted against the Chief Land Registrar. And that went all the way back to the April 2022 pleading, which was on 2 slides ago. And you'll remember, or maybe not, that was the pleading in which the 2 alternative factual cases were put forward. So, in fact, as a sideswipe to the rejection of the very latest pleading, the claimant was able to say, well, actually, I can take advantage of the fact that 3 or 4 versions ago, I put forward a pleading which put forward these 2 alternatives, and so those are still in play, and therefore you should allow the case to go forward. But you may remember that as well as applying for summary judgment, the Chief Land Registrar also applied for a strikeout for abuse of process. And in light of the twists and turns of the case, and in particular the way in which the claimant had signed multiple statements of truth verifying different factual positions, by the way, without pleading any evidential basis for those positions or explaining why there'd been a change, the Chief Land Registrar said, well, the way in which the claimant has pursued the case is the clearest possible case of abuse of process. And when it came to the decision, Mrs. Justice Smith agreed that there had been an abuse of the court's process. Now, her reasons were, firstly, the claimant's case on the facts had fluctuated from a position in which it was unclear as to whose the money was when it was stolen, to a positive averment that factual case A was correct, to a pleading in which factual case A and factual case B were both put forward as alternatives, then to a pleading in which only factual case A was pleaded, and then finally to a pleading in which only factual case B was pleaded. Secondly, all but one of those pleadings had been verified by the claimant with a statement of truth, but there'd been no explanation from the claimant as to how she came to sign these inconsistent statements of truth in the absence of any new evidential basis on which to do so. Thirdly, the claimant had, as I said earlier, been warned that she was in the last chance saloon in relation to her pleading. And then finally, it was plain that the claimant's case had been pursued in a confusing, I think we can all agree with that, and muddled manner, apparently designed to preserve her ability to advance any case that had a prospect of succeeding against any one of the defendants, and it changed in accordance with which defendant she was going after at any particular point in time. And what Mrs. Justice Smith said was that the most recent events, the switch from factual case A to factual case B in the last manifestation of the pleading, were clearly intended to overcome the factual points that had been made by the Chief Land Registrar in his application for summary judgment. And the claimant was seeking to, in the words of the judge, to pursue and verify whichever alleged set of facts is convenient to her cause in light of the ever-diminishing number of available defendants. And the judge went on to say that these do not appear to me to be proceedings which have been prosecuted in an ordinary, reasonable manner pursuant to the requirements of the overriding objective. And she considered that the only appropriate response was to strike out the claim. And the result of all of that was that the claimant's claim, which had started against 7 defendants, had been slowly whittled down, I think over the course of about 7 years, to only 1, which was eventually dismissed as an abusive process. Where does that leave us in terms of what we can learn from this? Now, in one sense, I think the decision is a striking one, not because the claimant wasn't flip-flopping all over the place, obviously she was, but in an earlier outing in the Court of Appeal, Lord Justice Nugie had commented that Mr. Al-Haq appeared to have had what he called the singular misfortune to be the victim of what appeared to have been 2 successive frauds in relation to the same property. So how, one might ask, did the claimant, having pursued the case for more than 7 years, come away empty-handed? The second point that's interesting in all of this is the emphasis placed by the judge on the fact that the claimant had signed multiple statements of truth verifying factually incompatible positions. But it does rather seem to me that that begs the question as to how a party in the position of the claimant was supposed to proceed. The reality here was that the claimant didn't have any real knowledge as to whether factual case A or factual case B was correct. And that was a point that had been expressly acknowledged in a previous hearing by the Court of Appeal in its earlier judgment. The point had been made again by Lord Justice Nugie that Mr. Al-Haq had died, and one assumes, he said, that Mrs. Ashraf, the claimant, had little personal knowledge of the facts, and that seems to me to be likely to have been correct. And in truth, it seems unlikely, even if Mr. Al-Haq had still been alive, that he could have helped very much on this crucial point, because obviously you're dealing with which part of the ledger the money was in the client account of FLP Solicitors at the point that it was stolen, and that was obviously not knowledge that the claimant or Mr. Al-Haq would ever have had. Now, Mrs. Justice Smith, in her judgment, referred to the case of Binks and Securicor, in which the Court of Appeal indicated that it is possible to plead alternative factual cases and still sign a statement of truth. But she distinguished that case. She said that it was difficult to see how that case justified what the claimant had done in the present case. And she said correctly that that in Binks, the court had indicated that a party could advance an alternative case based on the other party's pleadings or upon evidence. But what she said was that in the present case, the claimant was doing no more than saying that the facts may be one thing or the other, but she didn't really know. And the suggestion, it seems to me, implicitly from the judgment of Mrs. Justice Smith, is that a claimant in that situation can't plead alternative cases because they just don't know one way or the other what has happened. And it does seem to me that that is problematic. As I've said, it wasn't her fault, nor indeed the fault of Mr. Al-Haq, that they didn't know whose the money was when it was stolen by the thief at FLP Solicitors. That, of course, was FLP's fault. It appears, at least from the judgments, that FLP's ledgers had never been produced. Now, of course, those documents might have helped, but is a claimant unable to plead a case until he or she has got hold of the ledgers? We all know how difficult it is to get pre-action disclosure. Are we really saying that there's a vicious circle here that you can't get out of? You can't plead your case until you've got the disclosure, but you can't get the disclosure until you've pleaded your case. What the claimant did know was that there were two possibilities and that it was either one or the other. And I wonder whether we really are saying that the statement of truth rules should prevent a party from putting those possibilities forward so that they can then be investigated either through disclosure or via witness evidence. But following the judgment of Mrs. Justice Smith, it does seem to me arguably the position is that you can't do that. What can we learn more generally from the case about abuse of process? First of all, I think it probably is fair to say, no matter what I say about the knowledge or lack of it of the claimant in relation to whose the money was at the point it was stolen, the case is something of an object lesson as to how not to go about dealing with a situation like this. The claimant didn't know what the position was following the theft as to whose the money was. There were a number of alternative claims against a number of different defendants, and of course those claims depended on the answer to that question. So if, for example, the money was still held, had been still held on behalf of Mr. Otarian at the point it was stolen, then obviously the transfer of the property was incorrect, and there was a real issue as to whether the Chief Land Registrar in those circumstances should be compensating for the error on the register. Conversely, if the money, when it was stolen, had by that stage been received on behalf of Mr. Al-Haq, then the claim against the Land Registrar would obviously fall away, but claims against other defendants would hove into view. Now, the course that was taken by the claimant in this case was to sue all defendants who were potentially liable on either alternative premise. And that immediately put the claimant into a position in which she was under pressure, because all of the defendants could legitimately say, well, what's the evidential basis for contending either factual case A or factual case B? And what the claimant then did, and I think this is fundamentally what the mistake was in the case, and fundamentally what was really held to be abusive, was to sit on the fence and to flip-flop between the various different permutations or alternatives, depending upon which party she was facing in the context of whatever application was being made. And it's fundamentally, it seems to me, the sitting on the fence and the flip-flopping that did for her case. She wasn't helped, it seems to me, just by looking at the judgments that the various courts have produced, by the fact that she appears, one assumes for financial reasons, to have been unable to obtain consistent legal representation. She was represented by a number of different barristers at these hearings, and in the latter stages she was instructing a barrister on direct access. The second point I think to make about this situation is that if one is faced with this problem, and it does often happen in fraud cases, you just don't know, you've got alternatives, you just don't know what the position is. You know that there are a finite number of possibilities, it could be one or the other, but you don't know what the answer is. I think that the advice that one would give is the only thing you can do is to be upfront about that. It does seem to me likely that things might have been a bit different if a more consistent approach had been taken throughout these proceedings, i.e. if the claimant had said right from the start, well look, there are these two possibilities, I don't actually know whether it's one or the other. If it's this one, then here's my claim against these defendants. If it's the other, here's my claim against the second. I think you would also need to think about, if one proceeds in that way, how you're actually going to find out what the answer is to which alternative is correct. Obviously, it's possible that something will come up in disclosure, and if that is the approach you're taking, then you can say, we think it will all come out in disclosure, and then cross your fingers and hope that it does. You might think about whether you need pre-action disclosure or disclosure against a third party, and the fact that you need such disclosure to plead out your case may be one of the few reasons that the court might be prepared to make that sort of order. Alternatively, you might be in a situation where resolution between the alternative factual cases will only be established once you've got the witnesses in the witness box, and that can happen. And if that is the case, then again, say so. Say that to the court. there will be cases, it seems to me, in which it is actually wholly unclear how the court's going to resolve the question as to which alternative is the right one. So to take this case as an example, this was in front of Mrs. Justice Smith 15 years after the theft, 7 years after the proceedings had been commenced. From what the judgments say, the FLP ledgers still hadn't been produced at that stage, and I don't really know why not, but that does raise the question whether they ever would be produced. And you may be in a situation where you have to recognise that it's a situation in which the court is going to struggle to reach a conclusion one way or the other. And in that type of case, questions of burden of proof obviously are going to arise, and perhaps what I think is quite a difficult question of what is going to happen if you can't prove which of the two alternative factual cases is the right one. Do you have a situation where both defendants get off because you can't actually prove which of the two factual situations is correct? Thirdly, if acting for a defendant, you can see that there is some significant scope for procedural advantage in a case like this. When you're faced with a situation in which it's plain that a claimant doesn't know which of two or more factual cases situations occurred, then start pressing them for the evidence that they're relying upon. Mrs. Justice Smith was critical of the claimant in this case for failing to identify what the evidential position was that underpinned the factual alternatives, or perhaps a failure on the part of the claimant to acknowledge that they didn't really know. If in response to those sort of queries the claimant is obstructive or obscure, then that can be helpful later on in the proceedings, as it was for the defendant in this case. And it may assist ultimately in presenting the claimant as taking a speculative and opportunistic approach to the proceedings, which could end up being abusive. Ultimately, what I think the case demonstrates is how what one might have thought to be a case which had some intrinsic merit, Mr. Al-Haq, the victim of two frauds in relation to the same property, can ultimately be lost by a failure on the part of the claimant to get to grips with the dilemmas that are inherent in the claim and to face up to them squarely. So that's the Ashraf case. I'm now going to hand over to Benji, who's going to deal with the case I can't pronounce.
Thanks, Neil. If you are feeling downcast, having heard from Neil at the plight of Miss Ashraf, the good news is that the next story has a happy ending for the claimant. The bad news is that claimant is the Danish tax authority, so they're less likely to tug at the heartstrings. That is their name, and I'm not going to attempt it either. But the well-known principle in Henderson and Henderson was revisited earlier this month, judgment handed down on the 9th of February in the SCAT litigation. The SCAT litigation, as you probably know, is the Danish tax authority's claims against various entities arising from fraudulent applications for tax refunds, against which said tax authority paid out £1.44 billion. It's given rise to scores of decisions on all sorts of matters of procedure and substantive law since the various claims were issued in 2018 and 2019. And this case on abuse of process is the latest in this line. Now, one of the defendants in the litigation is the financial brokerage outfit MCML, formerly ED&F Man of summary judgment fame, which was alleged to have made requests for £70 million worth of successful refund requests from SCAT. And it did so, SCAT initially alleged, on the basis of negligent misrepresentations but not fraud, whereas frauds, claims in the tort of deceit, were made against all of the other defendants in the claims. The first hurdle in the litigation generally was the defendant's argument that SCAT's claim fell within the so-called revenue rule, which is the principle of private international law under which claims which seek to enforce the tax law of a foreign jurisdiction are inadmissible before the English courts. That defence succeeded in the commercial court in 2021, such that all of the claims were struck out against all the defendants. SCAT then sought permission to appeal and was granted permission on a limited basis, and important for these purposes because it excluded its claim against negligent misrepresentation against ED&F Man. So essentially the appeal was brought forward in relation to the fraud claims on the revenue rule judgment, only in relation to those other defendants, but not this one. As a result, success in the Court of Appeal would mean that the claim against ED&F Man MCML would remain struck out. So the appeal went ahead. The commercial court decision was reversed by the Court of Appeal in February 2022, and that decision was subsequently upheld by the Supreme Court. And as such, as I say, the SCAT's claims against all but the ED&F Man defendant were revived, and the ED&F Man claim remained struck out. So the somewhat to rub salt into the wound, the Court of Appeal said that its decision on the revenue rule would have applied even in a claim in negligence, irrespective of the fraud element. So had the claim been pursued, had the appeal been pursued in the ED&F Man claim, it would have succeeded as well, but tough. Fresh directions in the other defendant deceit claims were then made at a new CMC in May 2022 with trials laid down, a trial of another preliminary issue in January 2023 and a main trial set down for April of this year. And then on the 5th of December 2022, SCAT issued fresh proceedings against ED&F Man alone, in which SCAT alleged for the first time that ED&F Man knew that the representations in the tax vouchers were false or reckless. So I'm going to leave SCAT there for the moment and conduct a whistle-stop reminder of the principles in Henderson and Henderson in its long and glorious history since 1843. So the first point of note is that abuse of process itself is not a defined term in the CPR. The best catch-all is the Divisional Court's comments in Attorney General and Baker, noting that it means using the court's process for a purpose or in a way significantly different from its ordinary purpose. Perhaps some food for thought there to what extent that really applies on the All Falls of Ashraf. The principle in question here was formulated in Henderson and Henderson in 1843 by Vice-Chancellor Wigram, and in essence it precludes a party from raising in subsequent proceedings matters which were not, but could and should have been raised in earlier ones. So this principle operates as an alternative to the strict legal rules of res judicata, which are issue estoppel and cause of action estoppel. So the principle in Henderson is something of a softer-edged cousin to those legal rules. It concerns not matters which were decided in a previous action, but those which might have been had they been raised in that previous action. And so it is ultimately a rule of public policy, not a rule of law. And the principle that sits behind it is that litigation should not drag on forever, and a defendant should not be oppressed by successive suits, which are the words of Lord Bingham in the Barrow case. So the principle has then, of course, developed since the advent of the CPR in the context of the overriding objective and the duty to promote justice in the various objectives of saving time and costs in doing so. And the modern touchstone for Henderson and Henderson abuse is the Johnson and Gore Wood case. This emphasised in the points there, in the bullet points on the slide, the current emphasis on efficiency and economy in the conduct of litigation. Those points were put into 6 numbered points in the Dexter Limited and Fleeland Body case. That emphasised that the issue, which is not engaged in this case, where you have claims brought against party C, where party A had previously brought a claim against party B. So you've got those claims against a different party in a later claim. That's not the issue here. But the 4 points on the slide really can be summarised that the question of prejudice to the defendant and the broad merits-based analysis are key, and those are the emphases that really come through in the SCAT decision. So those principles are revisited and restated in the decision in SCAT, which is a useful place to go to for a compendious but not overlong revisiting of those principles. And the starting point is that one must be able to show, in order to establish a Henderson abuse, that one both could and should have raised the issue in question in the earlier proceedings. But once you've got the tick to both could and should, that is not on its own enough to establish abuse, nor will abuse become a rebuttable presumption once you can show that you could and should have raised the issue in those earlier proceedings. Now this feeds into the case management rule, which you'll no doubt be familiar with in the Aldi Stores case. And the rule is that parties must inform the court seized of the proceedings of other issues that arise for resolution in relation to that case. And Aldi Stores notes that there cannot be an excuse for failures in the future. It's very much one of those decisions where the court is going full headmaster. But what is noted in SCAT is that is a rule, it is mandatory, and there is a telling off that comes if you don't abide with it, but that does not mean that it's a sufficient condition for the finding of abuse. This was a point that was fought over in submissions, and the defendants relied on the observations of Adrian Zuckerman, who writes Zuckerman on civil procedure. And the view articulated there was, well, if there's been a breach of the Aldi Stores rule, which the court in Aldi Stores said was a mandatory requirement, that should lead to a striking out or at least a presumption of abuse. But what the judge noted in SCAT was that there was no case that had been cited to him in which a failure to comply with the Aldi Stores guidance alone led to a striking out of the case. That actually the previous jurisprudence all suggested that there needed to be some sort of harassment, oppression, unfairness, some sort of prejudice against the defendant. So it's a rule, but it's not a rule with any particular consequence. And finally, this review of the principles emphasised the importance of the factual sensitivity, looking carefully at the circumstances in which this second case, the new case, arises, and the circumstances in which it could and should have been brought forward. The Playboy case is one, which I mentioned on the slide, is one where a second fraud action was not struck out after the claim in negligence had been brought and failed. And in that case, the Court of Appeal decision held that it was rare that a party would ever be shut out where the issue in question had not been decided, and where ultimately there had been no deliberate keeping of the material up the sleeve, as it were. So you'll be sensing already, if I hadn't given away the ending, that this is something of an uphill struggle for the applicant. Now, the broad merits-based assessment is what Johnson and Gore Wood says ultimately we will need to be carrying out on these applications. What that requires is a detailed review of the new case in deceit and how it comes to be, and that is what SCAT does, and these are the following points these are the points that were emphasised. So the totality of the facts relied upon in relation to the deceit claim were not known until disclosure. disclosure involved 182,000 documents from this particular defendant. That, as the judge noted, required substantial detective work, checks being made with various individuals involved to work out what their knowledge of circumstances were, evaluation by an expert in the relevant sort of trading to consider whether the facts and matters alleged could be consistent with a case with an honest explanation. Now, the disclosure was provided to SCAT before the revenue rule trial in the commercial court in 2021. But given the steps that needed to review that disclosure, to do so before that trial was not practicable. And in any event, the disclosure wasn't relevant to the revenue rule point, which was simply a legal question. And so the judge held SCAT was entitled to defer that review until after that trial. So there was no obligation at that point to raise it on the facts. There was then a subsequent expert report produced in December 2021 for SCAT, having looked at this material, and the judge found that when SCAT had had the opportunity to review that report, that is the date when it could have pleaded fraud. It must have appreciated that it was in a position to allege fraud at that point, which it said was in the early weeks of January 2022, but it was not the should date. It was not the date in which it should have pleaded that case, because of course the revenue rule had shut out all of the cases, and it wasn't until it was reversed by the Court of Appeal that any case, in this case the fraud cases, were permitted to continue. So then you come to the Court of Appeal stage, and the judge decides that at that stage the Court of Appeal should have been told, for reasons of transparency and candour alone, that a case on deceit was in contemplation. And therefore that applied with even more force when the CMC in front of Andrew Baker J happened in May 2022. And at that point the Aldi stores rule applied, and the judge said that it was quite plainly a rule that had been broken, and said that it was extremely surprising that the deceit claim had not been mentioned at this point. So there is something of a blatant breach of the Aldi stores rule. But the kicker, as I say, is what difference did this make? In particular, what difference did it make to the defendant? And that is the crucial question. And it involves the consideration of the counterfactual. How would matters have been different? How would things have played out differently had the fraud claim been an amendment made at the earlier date, whether when the Court of Appeal decision was handed down or at the CMC, or even at any earlier date? If the claim had been made before the revenue rule trial, the consequence would have been that ED&F Man would have taken a greater role in the Court of Appeal proceedings, which it wasn't part of at all because that point was never appealed. It therefore would have shared the greater cost burden, and the same would have applied when the Court of Appeal decision went to the Supreme Court. So in fact, ED&F Man benefited from the claim not being made at that earlier stage. It got to sit back in the knowledge that the claim against it was not being appealed. It didn't have to contest that. It didn't have to turn up to that appeal and didn't have to share any of the cost. Because the issues in the new claim was now running completely separate to the claim against all of the other defendants, that was going to inure to the benefit of this defendant, because it was not having to be part of multi-party proceedings. Its claim was siloed and running along all on its own. So in that sense, no prejudice to the defendant. It had benefited from the fact that its claim had been brought at this later stage. Nothing that had been litigated before and decided before needed to be dealt with afresh. But obviously there is prejudice and there is some, inverted commas, harm caused by the fact that you have these two sets of proceedings now running in parallel and separate to one another. There is there's obviously an adverse impact on SCAT, it now has to run two sets of proceedings in parallel, but that's its choice, and it is the party that brought that upon itself. And there is also an adverse impact upon the court because it has two sets of proceedings instead of one. But ultimately, none of that impact on the court and court users was insufficient to overcome the absence of any prejudice to the defendant. And the broad assessment of the merits brings into focus actually what's in issue on that claim and the extent to which those issues need to be resolved. And ultimately, this is a very substantial claim. It's worth about £56 million. There is a substantial loss there, which of course SCAT has a very great interest in having resolved. There is a public policy interest, the court says, in having serious issues of fraud investigated on their merits. So ultimately, the failure to comply with the ALDI rules store is not enough. Prejudice is the touchword. The one point in the defendant's favour at the end of it all, and I don't know how this has been resolved, but what the court says at the very end of the decision is that in line with a similar case called Ott Critty and Threadneedle, the cost consequences were going to be very much in the defendant's favour. That case of Ott Critty is another failure to comply with the ALDI store's rule, but where no abuse was found, but where the judge had ordered that the claimant pay 75% of the defendant's costs of the application that the defendant had made, that it had lost. A decision which, in that rarest of rare things, was appealed to the Court of Appeal, and permission to appeal was given, and the Court of Appeal decided that it was within the remit of the judge to decide that costs order. So something of a similar costs order would no doubt have followed in the SCAT litigation. But it is a reminder of the really substantial uphill battle that one must fight, and that when we look back at ALDI stores and think, hang on a second, there's an absolutely clear as day breach of this rule in this case, we must all remember that note of caution. Unless it really made a difference to the defendant, it's not necessarily an application we are going to win. But even if it's not an application we're going to win, we might get our costs of bringing it, although query how long that will last if everyone's bringing applications that they know they're going to lose simply because they think they're going to get a generous cost order. Now, Discovery Land is an altogether harsher application of the principles on abuse, one that ultimately led to the same consequence in SCAT, namely that matters were allowed to proceed towards trial, which otherwise would not have been. The claim was brought against insurers following avoidance on the question of whether one director had condoned the fraudulent or dishonest acts of another director for the purposes of a common minimum terms policy exclusion. And the defendant had applied to amend its defence to add a case on condonation, which the claimants had conceded at the application stage was arguable. The claimants then applied for summary judgment 4 months before trial on the basis that that amendment to the defence was not properly arguable on a proper construction of the policy. In essence, they were arguing that condonation required actual knowledge of the particular acts or omissions, not mere condonation that the other director's running of the practice was in a way that amounts to a breach of professional conduct rules. So the application was resisted on two grounds. First of all, on its merits, that the condonation case had real prospects of success. And secondly, on the ground that the argument could and should have been advanced at the amendment stage, and that therefore to do so at this stage was an abusive process. And that part of it is the focus of today's today. Now, the claimant submitted that there was tension in the authorities as to whether or not the Henderson and Henderson principles apply with less rigour at the interlocutory stage. And they relied on a dicta from the Court of Appeal in the case of Woodhouse and Consignia to that effect. That had received subsequent comment and context, if I can put it that way, from Lord Justice Popplewell in the Koza Limited case, in which he had said that the Woodhouse dictum, that less strict rules apply in the interlocutory stage, should only be understood as a recognition that abuse is less likely because the risks of prejudice are lower at the interlocutory stage. But there is no general principle that the applicant in interlocutory hearings is entitled to greater indulgence, nor is there a different test to be applied at interlocutory hearings. The claimants also emphasised the practical benefit of disposing of the defendant's condemnation case and therefore saving time and costs at trial. In doing so, they cited the principles in easy air that we all know very well from summary judgment applications, and the idea that Mr. Justice Lewison emphasised of where there is a bad case on the law, we should grasp the nettle and decide it at the earlier stage. And they said both parties have put forward amended budgets which say that they're going to spend another £400,000 each dealing with this expansion of the case. It's right to hear the merit of it now and chuck it out at this stage. The defendants focused on the, in terms of the abusive process limb, on the question of the undermining of the finality of the judge granting the amendment application. And they said that this application was itself a distraction from the directions, including disclosure and witness statements, because of course this is 4 months before trial. And there is no good reason for allowing this U-turn on the decision at the amendment stage. The decision of Mrs. Justice Mulder was that the application failed on the grounds of abuse alone, such that she did not need to consider the merits at all, notwithstanding the opportunity presented here to grasp the nettle. And her reasoning, which is not long, is as follows. A whole day had been spent on the amendment application. In relation to the Court of Appeal authorities, she was satisfied that not only was Lord Justice Popplewell's comment right and correct, but actually Woodhouse was a very different case where new material that rendered the summary judgment application, in that case unanswerable, overrode the fact that it was a second bite of the cherry. And there was no new material in this case. So there was no change of circumstance to justify the change of position. And she noted how the claimant's own view about the merit of the point of construction had changed between the amendment stage and this summary judgment application. And she said that the fact that they held a different opinion earlier effectively refuted the conclusion that their new position was that the defence had no real prospect of success. Something of an odd conclusion, I'd suggest, in circumstances where she didn't consider the merits of the application at all. It simply relied on an inference about the claimant's solicitor's own view of the merits, as it were. And she also cited the problem of circumventing the appellate route if parties are allowed the second bite of the cherry in this way. But of course, that route wouldn't have been available to the claimants in circumstances where they hadn't asked the judge to refuse the amendment on this basis. But ultimately, this decision turns on the claimant's failure to take the point that they should have taken earlier. That decision was seen to be fatal, irrespective of whether the point had merit. So it's difficult to escape the sense that the focus here really is on the conduct of the party's representatives and less on the merits, and that one can trump the other. One factor to bear in mind in both cases that I talked about is that the party seeking to shut out the other's case failed to do so, such that effectively the shoes were each on the other foot. But there is something of a striking difference between the two cases and the approach taken by the judges. So the lesson must be that one has to proceed with real caution when agreeing any amendments to an opponent's statements of case, in recognition that allowing it is tantamount to a concession that they have real prospects of success. That one can't ultimately take a different position later unless there is a material change in circumstances that can be relied upon. That would risk being seen as being relitigating or having a second bite of a cherry. If one is seeking to argue these points in a future case, that may well be, and Discovery Land stands in one's way, putting it down to the particular facts of amendment and that the amendment application really is the point to test that principle, may be the way to get around what's otherwise a pretty tough decision. I've tried your patience for, I think, 1 minute more than I should have done. But thank you very much for listening.